Good afternoon, ma'am. My name is Vincent Edgar Hironda, fourth year basic criminology. I will tackle the chapter 1, which is legal medicine. Legal medicine is a branch of medicine which deals with the application of medical knowledge to the purpose of law and administration of justice. It is the application of basic and clinical and medical pharmaceutical science to elucidate legal matters. So, ang legal medicine daw ay ito yung tumutulong or isang application para malutas yung mga kaso na kailangang lutasin para maipaliwanag yung mga importanteng mga problema. Originally, the terms legal medicine, forensic medicine, and medical jurisprudence are synonyms, and common practice are used interchangeable. This concept revealed the countries under the Anglo-American influence. The terms legal medicine came from US, and the forensic medicine came from UK, and the term medical jurisprudence came from India. So the concept or practice legal medicine in the Philippines in Spanish origin. In modern times, especially continental European countries, legal medicine has similar meaning as the term forensic medicine. Although strictly speaking, legal medicine is primarily the application of medicine to legal cases, while forensic medicine concerns the application of medical science to elucidate the problems. So the difference between legal medicine and forensic medicine is legal medicine is concerned with the application of medicine in legal cases, while the forensic medicine concern the application of science para maipaliwanag yung mga problema na dapat na masolban. Juris means law, while prudence means knowledge. So, jurisprudence means knowledge of law. The next is the scope of legal medicine. So, the scope of legal medicine is quite broad and encompassing. It is the application of medical and paramedical science as demanded by law and administration of justice. The knowledge of nature and extent of wounds has been acquired in surgery, abortion, and death and effects of trauma in pathology, and etc. So, legal medicine can be used in surgery, abortion, pathology, and etc. So, the distinction between ordinary physician and medical jurist is an ordinary physician sees an injury or disease on the point of view of treatment. So, the ordinary physician can see or can find a disease by the point of view of treatment. So, by the example, by the surgery, doon mo malalaman yung kung ano ang dapat nagawing treatment sa isang pasyente. While medical jurist sees an injury or disease on the point of view of cause. Well, medical jurist can seize an injury. Makikita ang injury kung ano yung nangyari sa isang pasyente. Point of view of cause. Kung anong cause ng isang aksidente or ano man yan. The purpose of ordinary physician examining a patient is to arrive the definite diagnosis so that the appropriate treatment can be instituted. While the purpose of medical jurist in examining patient is to include those bodily lesions in examining in his report and testify before the court or before the investigation of the body, giving justice to whom it's. So, when we say ordinary physician, it is the doctor or the doctor is required to make an appropriate examination to know what are the right treatment or right medicine can be used in this victim or patients. While the purpose of medical jurist examining the patients is to include those bodily lesions. When we say lesion, it is the injury of a person. It is the injury of a person. It can be report to testify to the court that this lesion is caused by anything. Other definition. Number 1, law. Law, it is a rule of conduct, just, obligatory, laid by legitimate power for the common observance and benefits. So, there are 3 characteristics of law. Number 1 is it is rule of conduct. Second is it is dictated by legitimate power. And the third is compulsory and obligatory to all. So, When we say compulsory, we are obliged to follow and to follow and to follow the rules of the law of the Philippines. We have two forms of law. We have lex scripta and lex non scripta. When we say lex scripta or written or statutory law, this is composed by law which are produced by countries' legislation and which are defined, codified, and incorporated by lawmaking body. So, this written law is created by the legitimate legislation and defined making bodies. So example of this law is the law of the Philippines. The second is lex non scripta, unwritten or common law. This is composed of the written laws based on the memorial customs and usage. It is sometimes referred as to is law, common jurisprudence, or customary law. The example of this law is the law of England. Number 2, forensic. It denotes anything belong to the court of law or used in court or legal proceeding or something fitted by legal public argumentation. Forensic can be used in the court proceedings or something, or can be used in legal or public argumentation. Medicine. Medicine is a science and art dealing with prevention and cure and alleviation of disease. So, medicine is science na dapat na yung mga tinitake natin na sample dito, yung mga tinitake natin na mga gamot para ma-prevent yung mga sakit at para magamot ang mga sakit nating nararamdaman. Legal. Legal is that which pertain to law, bursting out by virtue of include law. Jurisprudence. It is a practical science which investigates the nature, origin, development, and function of law. It is a science of giving a wise interpretation of the law and just application of all cases as they arise. So, jurisprudence, ito yung nag-imbestiga kung saan o anong pinanggalingan ng isang, kung ano pinanggalingan at ano ang function ng isang law. There are 4 branches of law where legal medicine may be applied. First is the civil law. Civil law is a mass of precept that determines and regulates the relations of assistance, authority, and obedience between members of the family and those which exist among members of society for the protection of private interest. Second, the criminal law. Criminal law is a branch of or divides which define crimes, threats, and their nature or provide punishment. Ito yung nagbibigay ng punishment sa isang tao kung nakaviolate ka sa law sa ating bansa. Legal medicine is applicable to the following provision. First is circumstancing affecting criminal liability. Second is crimes against person. And the third is crimes against justice. The third is remedial law. Remedial law is the branch of or division of law which deals with the rule of concerning pleadings and procedure in all courts of the Philippines. So, there are 5 types of medical evidence. The first here is real evidence or autoptic evidence. This evidence may known as adverse to the senses of the court. It is not limited to that which is known as through the senses of vision, but is extended to what the sense of hearing, taste, smell, touch as perceived or perceived. So, ito yung mga ebidensya na kung saan included yung 5 senses natin. The second is testimonial evidence. So, testimonial evidence, a physician may be commanded to appear before give his testimony. His testimony must be orally and under the affirmation. So, testimonial evidence is ito yung magbibigay ka ng iyong testimony sa isang korte or yung na ikaw yung magiging witness orally, dapat orally mo ibibigay yung mga information to testify na that person is nakita mo talaga yung ginawa niya. There are 2 types of testimonial evidence. Number 1 is ordinary witness. A physician who testify in court matters from his patient in the course of patient is considered as an ordinary witness. The second is expert witness. A physician on accord of his training and experience can give an opinion set of medical facts. So, ito yung mga expert witness na dumaan sa training and they have more experience in testify in the court. The third is experimental evidence. A medical witness may be allowed by the court to confirm his allegation or as collaborated proof to opinion his previously stated. So, The fourth is documentary evidence. A document is instrument on which recorded by means letter, figure, marks, intended for purpose recording that matter which may be evidentially used. Documentary evidence, so ito yung kailangan mo na may record ka, marks, figures, upang magamit mo to sa korte. The sample of medical documentary evidence may be medical certification, medical examination, physical examination, necropsy, autopsy, laboratory, inhumation, birth, death, medical expert opinion, and disposition. The fifth is the physical evidence. These are article and material which found in the connection with the investigation and in establishing the identity of the perpetrator or circumstances under which the crime was committed or general assist in the prosecution of criminals. When physical evidence, ito yung mga nakikita mo sa isang crime scene, yung mga bagay o bloodstain or sample bloodstain, sperm. Dapat mo itong i-collect na mga physical evidence to present to the court, and it should not be contaminated. Corpus delicti evidence. Corpus delicti evidence, object or substance may be part of the body of the crime. The body of the victim of murder, prohibited drugs recovered from the person, blood stain or fingerprints suspect, stolen motor vehicle, identified plate numbers, and bodily engine serial number are example of corpus delicti. When we say corpus delicti, ito yung talaga yung body of crime. Dito na example sa murder. Body of crime of murder is the cadaver itself. Stolen motor vehicle, it must be identified and it must preserve all the evidences found in the body of a person or a thing or a motor vehicle is stolen. Associative evidence. These are physical evidence which link to the suspect to the crime. Number 3, tracing evidence. These are physical evidence which may assist the investigator in locating the suspect. Ito yung mag-a-assist sa isang investigator para matrace kung sino, kung saan, or anong pinangyarihan para malocate yung isang suspect o criminals. The methods of preserving evidence. So, there are the third is remedial law. Remedial law is the branch or division of law which deals with the rule concerning pleading, practices, and procedure in all court of the Philippines. So, legal medicine can be applied in the following provision of the rule of court. So, it can be applied in physical and mental examination of person. Second is proceeding hospitalization of an insane person. The brief history of legal medicine. So, the first is, in the world's wide scale, the earliest recorded medical legal expert was Imhotep. Si Imhotep yung was medical legal expert si Imhotep. The Code of Hammurabi, the oldest code of law, in 2200 BC. Hippocrates in Greece discussed the lethally wounds. Aristotle fixed the animation of fetus of 40th day after conception. The first police surgeon or forensic pathologist was Antistius. Justinian, in his digest, made mention that physician is not an ordinary witness, and that a physician gives. Pope Innocent III issued an edict providing the appointment of doctors to the court to determine the nature of wounds. Paulus Zacchaeus, a papal physician regarded as a father of forensic medicine. Perrin Severin published a Paris work of deflammation. Orfilia introduced the methods of toxicology in his trade deposition. He was considered as the father or founder of modern toxicology. On December 23, 1975, Presidential Decree 856 was promulgated, and Section 95 provides a person authorized to perform autopsy are: number 1, the health officer. The second is the medical officer of law enforcement agencies. And the third is the member of staff of accredited hospitals. So, ito lang yung tatlo na pwedeng are authorized na mag-perform ng autopsy sa isang cadaver. Medical evidence. Evidence is means sanctioned by the rule of court as ascertaining judicial proceedings the truth respecting the matter of fact. Section 1, Rule 1 to 8, Rules of Court. Admissibility of evidence. Evidence is admissible when it is relevant to the issue and is not excluded by the rule. Section 3, Rule of Court, 1 to 8, Rules of Court. So, admissibility of evidence. Evidence must be admissible kung ito ay relevant sa isang kaso. Relevancy of evidence. Evidence must such as relation to the fact in issue as to include beliefs, its existence or non-existence. Therefore, collateral matter shall be allowed expert when they degree to establish probability and the fact issue. Section 4, Rule 138, Rules of Court. There are Let's proceed to identification. Identification is the determination of the individuality of a person or a thing. The importance of identification of a person. The first is, in the prosecution of the criminal offense, the identity of the offender and that the victim must be established. So, kailangan talaga ma-identify kung ano ang identity ng isang offender or a victim. And rules in personal identification. The first is the greater number of point of similarities and the similarity of a person compared, the greater is the probability of conclusion to correct known of law of multiplicity of evidence. The second is the value of different point of identification varies the formulation of conclusion in fresh cadaver. If the fingerprint of file are same, those covered from the same crime scene, they will be positively established the identity of a person, while bodily marks, scars, complexion, shape, nose, etc. are merely corroborative. Methods of identification. The first is by comparison. Identification criteria recovered during investigation are compared with records available in the file, and post-mortem findings are compared and ante-mortem records. Example of by comparison. The first is Latin fingerprint. Latin fingerprint recovered from the crime scene are compared with the fingerprints of file of investigating agency. So, Latin fingerprints, ito yung mga pagdating mo talaga sa crime scene, kailangan mo talagang kunin yung fingerprint ng isang cadaver para ma-compare ito kung saan ito imbestigahan. Dental findings. Post-mortem means after death, while ante-mortem is before death. Kinds of death. There are three types of kinds of death. Number one is clinical or somatic death. The second is molecular or cellular death. And the third is apparent death or state of suspended animation. Physical injury brought by physical violence. So, physical injury is damage to the body caused by external force. So, ang physical injury is ito yung injury na ginagamitan mo na force sa isang tao. Ito yung magkakos sa kanya ng physical injury. Example is scratching or biting. The second is pushing or shaving, slapping, kicking, shocking or struggling, throwing things, force feeding and denying you food, physical restraining you, reckless driving, and other act hurts threaten you. Wounds. Physical violence of person leads to production of wounds, which is description of anatomic integrity of tissue of the body. Vital reaction. Sum total of all reaction of tissue or organs to trauma. The following are the common reaction of living tissue trauma. Rubor. The second is color. The third is dolor, pain. 4 is loss of function. There are 8 classification of wounds. The first is according to etiology. Second, according to rank. The third is according to duration. The fourth is according to integrity of skin. The fifth is according to the wound of death. The sixth is according to morphological characteristic. And the seventh is according to degree of contamination. And the eighth is according to severity. According to etiology, surgical wounds. These are wounds caused by surgical procedure. Opera, example, opera, surgical. Penetrating wounds. These are wounds caused by penetrating trauma. Blunt wounds caused by blunt trauma. Burn wound caused by burns injury. Example of this is arson, yung pagkasunog. According to rank of health class system, tidy wounds. These are wounds inflicted by sharp instrument and tissue, such as can be primary with expectation and acute primary healing. They have single clean associated features and common tidy wounds. Example of tidy wounds is penetration of a knife. According to duration of wounds of healing, acute wounds. These are wounds that heals in anticipated time of frame. Duration of the wound immediately to a few weeks. Example of wounds acquired to resolve trauma and operative procedure. Chronic wounds. Wounds that fail to heal in the anticipated time frame and often re-over. According to integrity of the skin, open wounds. Type of wounds in which skin has been compromised and underlying tissue are exposed. Open wound can be classified as number of different types according to object use of. Example of this is laceration. Closed wounds, in which the skin has not been compromised but trauma to the underlying structure has occurred. Example of closed wounds is bruise or hematoma. According to wound depth, spherical wounds. Only the epidermis is affected. A truly spherical wound does not bleed and heal within a few days. Example are the most abrasion of blisters. According to morphological characteristic, these are closed wounds caused by blunt trauma that damage tissue under the skin without breaking the skin. Example are blow to the chest, abdomen, or head blunt instrument. Crush wounds. Crush wounds are accused by great extreme amount of force applied over the long period of time. They are often accompanied by niggling injuries, compartment syndrome. Lacerated wounds caused by tearing tissue. Wounds have irregular borders, loss of tissue limited to skin and subcutaneous tissue. Penetrating wounds caused by sharp pointed objects like nails have relatively small openings and may be very deep. Penetrating. When I say penetrating, yun talaga yung pag example is yung bala. Pagputok mo, pagtatama ay lalabas gagawa siya ng ibang butas, yung papasok talaga at lalabas, yung penetrating. Serious physical injury. Article 236 Revised Penal Code. Any person who shall account with assault another shall be guilty of crime serious physical injury. Serious physical injury, yung i-assault mo yung isang tao and it can cause a physical injury, physical damage of a person. The physical injury, serious crime, would encompass around, the first is wounding, the second is beating, the third is assaulting, and the fourth is administering injury substance without the intention to kill. Methods in preserving evidence. Number 1 is photography. Photography is considered to be the most practical and reliable means of preservation. So, ang photography is ito talaga yung pinaka-practical na pag-preserba ng isang evidence to photograph. The second is sketching. There are two types of sketching, the rough sketch and the finished sketch. Rough sketch is made at the crime scene or examination of living or dead body. So, dito mo i-sketch yung isang body ng isang cadaver to examine the cause of death. The finished sketch. The second is the finished sketch. Dito mo na yung rough sketch mo gagawin mo na tong finish through draw the body of a person. I-draw mo to and ito na yung i-presenta mo sa korte. The third is description. This is putting of the word the person to be preserved. Dito mo na lalagyan ng tagging kung anong oras mo na-collect ang isang ebidensya sa crime scene. Skin lesion. Kind of measurement, other descriptive information to the lesion itself, location, orientation. The second is penetrating wound. Penetrating wound, ito na yung mga tama ng bala or yawa kaniwala ka. Let's proceed to Chapter 5, Medical Legal Investigation of Death. An inquest officer and an official of the state charged with the duty of inquiring into certain matters. In a medical legal investigation, an inquest officer is the one who charged with the duty of investigating the matter of cause of death of a person. He is authorized to summon, witness, and direct any person to perform or assist investigation when necessary. So the medical legal investigation is in charge to investigate what is the cause of the death of a person, and he is authorized to make and summon to to assist the investigation when necessary. The provincial and city fiscal. The provincial and city fiscal are the MTC, Municipal Trial Court, the RTC, Regional Trial Court, lower courts. The Provincial City of Fiscal, Section 983 Revised Administrative Code, the District Health Officer, upon the request of Provincial Fiscal for province within the district of any judge of court first instance, RTC, or any justice of peace of now municipal trial court shall conduct in person when practicable investigate in the case that where suspicious death was caused by unlawful act or omission of a person, and shall such investigation as may required in the proper administration of justice. Second is judge of court and the first instance. The third is justice of peace, municipal trial court. The fourth is director of National Bureau of Investigation. The fifth is the chief of police of the city of Manila. And the sixth is Solicitor General, or the attorney. The stages of medical legal investigation. Crime scene investigation, investigation of place, commission of the crime. So, crime scene, ito yung pinangyarihan ng krimen. At dito iniimbestigahan kung ano ang dahilan ng pagkamatay ng isang tao. Autopsy, investigation of the body of the victim. Dito na ang autopsy ginagawa kapag crimes against person yung krimen. Crime scene investigation. Crime scene investigation, place where essential ingredients of criminal act took place. It includes setting of crime, also adjoining place, and entry exit of offender and victim. Not all crimes have well-defined some estafa, malverse, continuing crimes. However, where medical evidence may be present like murder, like homicide, physical injury, sex crimes almost heavily present. Crime scene investigation include the appreciation of each condition and drawing of inference from it. It includes the collection of physical evidence that may lead the identity of the perpetrator, manner criminal was executed, such as things that may be useful is the prosecutor of the case. So, crime scene investigation, dito mo malalaman kung the purpose of crime scene investigator is to know who is the perpetrator of the crime. In violence death case, the manner of cause of death may be inferred with the condition of crime scene. The condition of crime scene may be indicate struggle, handgun firmly grasps, presence of quantity of the blood may infer hemorrhage at the cause of death of victim. Person composed to Birch team. The first is the physician, who have the previous knowledge of training medical investigation must the search assume responsibility of the effective search. So the person who can search the crime scene is the physician, because he or she have the knowledge to investigate the crime scene, or he or she have the knowledge to search the crime scene. And the second is the photographer, who will take the pictures, crime scene, piece evidence card, he may sketcher and measurer. So, the photographer the, the photographer is will take photo and pictures of the crime scene, and also he will make measure uh, on sketch of the crime scene upon evidence, and after that evidence must be collected. Equipment needed in the crime scene investigation. Those needed search physical evidence. So, ang mga kailangan pag-search ng mga physical evidence is the first is the flashlight and magnifying glass. So, kailangan natin yan para mas mapadali ang pag-search sa isang ebidensya upang madaling makita ito. Choose needed collection evidence: forceps, knife, scalpel cutting instrument, and filler, pear, scissor, and finger prick kit. Ito yung mga kailangan natin para mas mapadali ang pag-imbestiga sa crime scene. So, there are five methods of conducting search. The first method these methods are before the actual performance search, the advisable stand, make estimate of the situation picture, stand, make estimate, whole area must be taken, are the most cordoned by the most allowed get in. So before the crime scene investigator the first respondent must cordon the area, and must not all the people around the crime scene must not enter in the crime scene to avoid contamination of the evidence. So the first method is strip method. These are blocked out form which rectangular searcher proceeds slowly on the same pace along the path parallel to a side the rectangle. So ito yung pagsunod-sunod ng mga team leader to photographer, dapat naka-strip yung galaw nila, ang pag-search nila. Double strip method, the researcher will traverse first parallel to the base and the parallel to side. And the third is spiral method. The searchers follow each into the path in spiral manner beginning to the center towards outside, so vice versa. So sa loob hanggang sa labas, paikot sila sa pag-search. The wheel method, changes of the following that changes in the muscle. After that, there are complete relaxation of whole muscular system. The entire muscular system is contractile for 3 to 6 hours after that, and later rigidity sets in. Secondary relaxation of the muscle will occur just when decomposition has set in. The entire muscular tissue passes the stage after that. Letter A. Stage of primary flaccidity. Post-mortem muscular irritability. The muscular are relaxed, are capable of contracting when are incontinence or urinary dysfunction. Letter B. Stage of post-mortem rigidity. Cadaveric rigidity or death struggle of muscle or rigor mortis. The whole body becomes rigid through due of contraction and muscle. This develops 3 to 6 hours after death, lasts from 24 hours to 6 hours. So the whole body will rigid, maninigas yung body ng isang cadaver to 3 to 6 hours after death. Maninigas ang bangkay 2 to 3 hours after death. Stage of secondary placidity of commencement of decay of muscle. The muscle become placid, no longer capable of responding to mechanical and electrical stimulus, and this becomes alkaline. Let's proceed to changes in and about the eye. Loss of corneal reflex. Loss of corneal reflex. The cornea is not capable of making reaction what is very intensity light stimulus. However, absence of cornea reflex may be also found in living person. The following conditions are: number 1, general anesthesia. Second, apoplexy. Third, urimis. Fourth, epilepsy. Fifth, necrotic poisoning. And the sixth is local anesthesia. Let's proceed to autopsy. An autopsy is a comprehensive study of a dead body performed by the trained physician employing recognized dissection procedure and techniques in removal of tissue for their examination. So, a person who conduct autopsy must the cause of death, providing the correlation of clinical diagnosis, clinical symptoms, determining the effectiveness of therapy, studying the natural cause of disease process, and lastly, educating student and physician. Medical, legal, or official autopsy. This is an examination performed on a dead body for the purpose of the first is determining the cause of manner, mode, and the time of death, recovering and identifying preserving evidentiary materials. Third is providing interpretation and correlation facts circumstances related to death. And the fourth is providing factual objectives, medical report of law enforcement, prosecution and defense agencies. And lastly, separating the death due to disease from death due to the external cause of protection innocence. Procedure of autopsy. B. In an official, medical, legal, or official autopsy, the pathologist must be properly guided by the purpose for which autopsy is to be performed. Is so doing purpose arc dissection will serve to determine the element of all. The autopsy must be comprehensive and must not leave some parts of the body unexamined. So, lahat ng mga tissue sa isang cadaver must be examined. Even the findings already sufficient the amount of death, this should not be sufficient reason for premature termination of autopsy. Third, bodies are severely mutilated, causing damage and suitable for autopsy. No matter now, portrayed fragmentary and remains are carefully examined must be deductive and information that bears to identify the physical trauma received. The fourth is, all autopsy must be performed in a manner which shows respect to the dead body. Unnecessary decision must be avoided. So, kailangan yung pag-dissect ng isang cadaver o body ng tao must be properly and not be hindi lang yaga-yaga. Kung kailangan seryoso ka sa pag-dissect ng isang body ng isang cadaver, must show respect to the cadaver even if it is dead already. Proper identity of deceased autopsy must be established. Non-official autopsy, an autopsy on a wrong body may be ground for damage. So, kailangan talaga kapag nag-autopsy ka sa isang cadaver, yung findings mo ay dapat yun talaga yung findings, hindi yung gawa-gawa na findings lamang. Kumbaga, tinuod jud siya na makatotohanan. Number 6, a dead body must not be embalmed before autopsy. Embalming fluid must be rendered tissue. The embalming may alter, gross appear the tissue, may result wide variety artifact that destroy the obscure evidence. So, kailangan talaga pag nag-autopsy ka, dapat hindi na-imbal mo yung patay. Kailangan talaga mismo cadaver, hindi pa na-imbalbo, hindi pa nagalaw. Dapat yun ang pag-autopsy mo. The body must be autopsied in the same condition when the crime scene. A delay of performance will foil possible finding thereof, serving the best time of justice. So, kailangan talaga pag-autopsy, on time talaga. Must be autopsied in this condition in the crime scene. A delay in performance, kapag na-delay ito ay magiging fail sa investigation. Rules in examination. There are 3 rules in examination. The first is look before you cut. So, kailangan talaga tignan mo muna bago i-incision. Never cut unless you are cutting. Hindi mo dapat i-cut yan kapag hindi ka sure sa pag yung hiwain mo. Weigh and measure everything that can be measured. Dapat talaga timbangin and i-measure mo talaga. Stage of postmortem examination body be primarily examination of surrounding crime scene. Dapat i-examine mo muna yung crime scene. Examining of clothing, dapat i-examine mo din yung clothing ng isang body ng cadaver. Identity of the body. Determine the height. You must determine the height, the width, and the color of the hair and eyes. Scars